distinctions are. We have a whole class on overhead, so I don't want to spend a whole lot of time there. I'm going to touch briefly on schedule. Again, this applies more towards construction. It applies to A&E services or any place where you have a schedule, where you have an agreement, again, in paper, on writing, with the government, and how to track those impacts, or when you are late or they've caused you to be late. Touching very briefly on getting paid, very briefly, in construction it's more important because we have progress payments and what the rules and regulations are and how they can withhold or retain money, and that's more important in construction, so we may touch on it. I quickly want to go over this. This is when I first retired from the government. One of the first things I did, I was asked to sit on a panel, and I was working with Mr. Scott Wakefield, who has since retired and sold PSW Electric. But he wrote a article for the Daily Journal of Commerce entitled 10 Stupid Things Contractors Do to Mess Up Federal Contracts. And he sent it to me and I read it and I thought, oh my gosh, this is still true today, very true today. So I use this as an opening whenever I can, but here's the 10 things that contractors do to mess up their own contract. The contractors always try to solve the government's problems. Now that I'm working for a private company in the private sector, it is I understand this even more so than ever. The mentality is we got to solve the client's problems, and the government doesn't operate that way. They want to solve their own problems. That's what they have a great staff for. They have hire A&E contractors to do. They like to solve their own problems, and contractors always try to step in, go off and solve their clients' problems, and that's something that will mess you up. Contractors proceed on change orders before entitlement is settled or cost is agreed to. Again, totally different from the private sector. The government believes and instructs you in your contract very clearly that no changes, no other work can be done before a mod and money is on the table to solve that. Now you have to remember that any federal contract is using federal dollars, taxpayer dollars. And that's why these rules are so important, that a government individual and contractor can't be standing out in the field, just make a decision and arbitrarily just agree to an amount of money. There is a process, and that's why this is so important. They love their paperwork, and these are things the contractors always go off and say, I trust you, I believe you, I know you're going to give me that change order, and I'm going to get it down the road. There's so many checks and balances in the system that generally that gets undone. Contractors fail to track costs for the extra work separately. Again, there's a lot of a trust factor going on. If I tell you it's $20,000 for this change, we agree, I go off and do it, and I come back to ask you for that, they're going to say, where's your records, where's your bills, where's your backup? Again, all related to paper. And if you don't track that, keep track of that, separate your costs, even set up a job order number to track it, you're going to find yourself denied those costs. If you can't explain it, they won't pay it. Contractors assume that government will explain their rights to them when settling changes. And this is kind of global. A lot of contractors assume that the government is going to explain how to do a government contract with them. And I can guarantee you that that is not true. Again, very much so the government is not going to talk to you. They assume that if you've got the contract, you are off and running and you know what you're supposed to be doing. They have a lot of other things going on, including their own mission, and they are going to go off and do that. I'm sorry. Contractors assume the government interpretation of the contract documents is correct. This again is a fallacy that trips contractors up. The government's interpretation isn't always right. The government's interpretation is in their favor. They've made a mistake. If they've forgotten something, they're going to try to explain that that's what they've meant. And we assume that they're correct, and we should just assume those. We should make those changes, and we should go off and do it. Again, those assumptions are going to trip you up in your contract. The contract is very clear. Contract is written out. It is subject to interpretation, but it is it is very much written down, and we need to assume that we can have an opportunity to interpret it also. Contractors fail to notify the government of changes, impacts, and delays as they occur. Again, the government is very specific in the contract, and we're going to talk through some of your clauses. They give specific requirements on when you have to notify them. You have to do it in writing. You have to give them the notice within a certain number of days, or in fact, you've waived your rights. They're very specific about that. Contractors finance the performance of changes to the government. I can tell you now, as I work for this private firm, that we are millions into the government for work that was performed that we have not been reimbursed for. It's a large company, and it's still very painful that we proceeded with changes on, of course, these top ones, good faith. We assumed that they were going to pay us, and now we are in there's litigation going on several of our jobs trying to get paid for those things that we did do in good faith for them. This happens a lot. Contractors finance the performance, oh, got that. Contractors fail to understand what costs they're entitled to when recovering those changes occur. This is something I see a lot. Matter of fact, I saw it as a contracting officer. Sometimes I had a REA, which is a request for an impact to be paid for an impact, and it could be 3, 4, 5 years old because, again, the government's in no big hurry to process their money to you. And the price never changed. And it always kind of amazed me that how somebody's price could still be the same after 4 or 5 years. You've got to be incurring costs. You have, even on work that pushes out a contract, you're going to have labor escalation, material escalation, and contractors fail to understand what costs they are actually entitled to. And this will end up costing you on your bottom line. Contractors allow the government to intimidate them when negotiating change. Scott used to say that this was like negotiating with an 800-pound gorilla in the room. The government is the sovereign. The government is king. The government has all the rules behind them, and they do try to intimidate contractors, very much so. Contractors fail to administer change like a separate job. And that, again, kind of touches on tracking your costs separately. But again, we should be negotiating these. We shouldn't be doing any of this work, just as if we got a new contract. We shouldn't be doing any of this work until we have it settled in a modification or, quote, a separate contract negotiated. The reason I go over these is because you may recognize some of these, you may be experiencing some of these, but this was written back in 1995. This is 25 years ago, and these same issues are plaguing contractors even today. So I want to talk about how to solve some of those. Kathy, can you still hear me? I hate talking to myself.
Yes, I can. And
okay.
I encourage people to interrupt you with questions.
Thank you, because I could be talking for, I don't know, hours. And, you know, again.
Okay, people, so that means you have to interrupt her. So those are your marching orders.
Those are your marching orders. Otherwise, I will check in once in a while. Let's go the other way, Mona. Okay, so here's a couple rules that I'd like you to and Kathy will make this slideshow available to you. Here's a couple rules I'd like you to try to follow when in your government contract. Follow the contract. You need to know, what does the contract say? And I can guarantee you that somewhere in the contract, it explains what to do. You know, there's a swim lane for everything. And that contract is very thick, and it's going to tell you exactly what to do. Put something in writing, notify within so many days, do this, perform that, submit this. And it is very clear. So somewhere in your contract, it's going to explain to you what you need to do. It may not be very clear, and that's what the PTAC is here to help you with, is help you understand that. But the government, if you call the government and ask them, hey, I got an impact, what should I do about it? They're not going to offer you any help, okay? Again, the rule is follow the contract. Do not overthink it. Do not redesign it. Do not try to make it better. The government has very specific criteria. I once had a contract for a very, very large construction project, and the construction contractor came in and said, you know, we think your A&E is kind of, you know, smoking some strange stuff, and we think we can do this better. And they tried for a number of months to get us to change it. I finally had to explain to them that I paid over $8 million for the design of this large construction contract, and that I had probably 300 people review that before it ever got to them. And they just need to follow the contract. So the government invests a lot of time, a lot of people are involved, I can guarantee you. So don't try to over design it, don't try to rethink it, don't try to make it better, do what the contract says. More importantly, do not try to understand it. Do not try to interpret the rules per se, or why the government is acting in a certain way. These are years and years of policy in the making. And most FAR requirements and most new requirements are driven off of a court case or something that was done poorly in the past. So again, follow your contract and follow the contract's rule number 1. Rule number 2, only the contracting officer can change the contract. Somewhere in your contract, it's going to tell you, this happens to be an NFAS, which is a NAVFAC supplement to the FAR. And somewhere in your contract, it'll tell you who has authority to change your contract. And somewhere in your contract, it'll tell you only that person, only a contracting officer can change the contract. And anything you're told otherwise during a meeting, during design review, during any kind of job walk, that is not binding on the government. And I have seen more cases and more REAs and issues thrown out because they didn't follow this simple rule of only the contractor can make the change. It is not bad for you to say, I understand what you want, but we need to get the contract officer to tell me to do that. Rule number 3, document, document, document. If there is an issue, you put it in writing. If there's an agreement, it needs to be in writing. If there's a change, you've got to get it in writing. You're asked to do something, again, get it in writing. Now there's going to be issues where it's meeting minutes or maybe an email follow-up, and perhaps we're stepping away from the contract officer giving us direction, but get it in writing, okay? If you have put it on a log, keep it on a schedule. And the number 1 rule, if you get down the road and you are in a situation where you have to end up in court, you cannot recreate history. So create it now while you're working on it, but get everything in writing. Again, the government loves their paperwork. Number 4, the government team did not get the email. Now, back in 1861, President Lincoln called for the changes in the Court of Claims, and he said, "It is as much the duty of the government to render prompt justice against itself in favor of the citizens as it is to administer the same between private individuals." At this point, President Lincoln said, if the government acts like a private sector, it has to behave like a private sector, which means we can sue the sovereign. We can sue the government. They are now being treated in the acquisition world like a private sector, and there are rules to follow. But the government team didn't necessarily get that. They kind of believe that they're above reproach, that they can make the rules, that they can make interpretations. I have in myself as a construction administrative contracting officer, lowered the boom, told them what to do, told them to claim it. So the government believes that they are the sovereign. They're the king. But President Lincoln, in the setting up of the acquisition rules and regulations, said when acting like a private company, they have to be treated like a private company. But they didn't necessarily get their rules. So just remember that. Okay, I'm going to keep going on. These are your swim lanes, okay? And I'd like you to keep this. If you're ever in doubt when you're working on your government contract, these are your swim lanes. When I say swim lanes, there's a little note over there. Emails, no emails. We're not communicating by email. There is no email, okay? Kicking tires, if you're out, what we refer to that in the construction world isn't a very old term, but if you go out in the back 40 and you're having a discussion offline, basically, not on the record, you can work out some deals and stuff, or you can solve some problems, but at the end of the day, when you come back into the trailer or into the office, you've got to live by these swim lanes, and it's got to be in one of these swim lanes. We are finding more and more cases, and there are going to be more and more in the future, where court cases are lost because of somebody's email. There is too much. It's not just a phone call anymore. It's not just his word against their word. It is going to now be written documentation where people are putting everything that they even think in emails, discussions. I sat in an arbitration where a client basically lost because the contractor was claiming that there was a differing site condition that was being hindered by about 20 feet of snow up in a forest job that he was working on. And he claimed that he had to demob and to go home and do some other things. Well, the contract officer pulled out an email that basically was for the superintendent that said, hey, I'm out of work, so I'm going home. I have nothing to do. At the end of the day, they lost because an email hurt them. So if I was queen for a day, I would take email communication away from everybody. It is really just a stamp. You can use it as a transmittal of any of these documents, but it is not a place for any discussions to go on. And more court cases are going to be lost from that. So we're going to go through some of these very quickly to talk about what happens in these swim lanes and why they're important, okay? Submittals, I know in design and in construction, perhaps even in procurement processes, you will have a submittal. The government, again, loves their paperwork. So they'll say, this is what we want. But before you start that, either construction or the design, tell us what you're going to give us. Or as you're designing it, give me a design submittal that communicates to me in writing what you're going to do for that product. I want you to remember a couple of these rules. The government has established, in most cases, a quality control, the contractor to have a quality control process. They have passed that back to the contractor and said, you have to inspect it. You have to make sure it complies with the contract requirements, and you have to certify that it does. Now, again, when the government asks you to certify something, they're very serious about that. You have to state that it complies with the terms and conditions of the contract. So there's some important things that you need to remember. If you're offering a substitution or a variation, or you're making a change, or you've made that change upon someone's direction, you need to note that in your submittal. If you don't, and you certify, yep, this complies, then basically you sold it. There's no change, there's no going back. You bought it and you sold it to the government for what you said you would do. Never resubmit unless directed to do so in writing. This is a trick of the government where they might have been sitting on your submittal, and in design this happens all the time. We haven't gotten around to reviewing it. They've been sitting on it. They have a contractual requirement to review it in so many days because we have an agreement, and they've been sitting on it, and they call you up and they say, hey, I've got a few changes you need to make. Can you resubmit that? And the contractors go off and say, sure, I'll go make those changes and I'll resubmit it. Well, what happens is you start that clock over. And if you're worried about schedule completion or getting things done on time, you have just voluntarily resubmitted that. You need to very politely tell the government, I understand your comments, return them to me and we'll process them accordingly, okay? This is just a standard trick that the government loves to do, and we'd love to share that with you now. Everything required by the contract, other than say some forms for badges or something like that, really should be on a submittal transmittal. It's really, we're passing paperwork back and forth. And again, the contract is very clear. We want a submittal process. This is what's going to happen during the submittal process. This is who has to sign off on it. This is how many pages you have to give me. And too many times we're passing forth the email without a cover sheet on it, basically tracking that document, signing off on it, getting the proper approvals. So make sure that it is submitted as a submittal if you're required to do it. When the government review period has expired, this is for people that have schedules and actual contractual completion dates. Design is one of them. Construction is quite, I mean, that always happens in construction. And even on services, I mean, supplies, where you might have had to submit a product detail, but you still have a completion date. And the government has a period. They've told you how long they will have to review it. And forever the government is trying to get past that date. They are overworked. They have too many submittals on their desk. So again, we have a problem. When they get to the end of their contractual period, what do? How do we handle that? Well, most often, again, we go back to the rules that I talked, or the issues that Scott Wakefield brought up in 1995. We solve their problem for them, or we just sit and wait patiently for them to do that. And again, we need to find a way to communicate to them that their time is up and we need a decision, because we have a contract and we have a completion date and we have to make that. We can't just sit on it waiting for them to decide or take it upon themselves to let us know when they're going to get around to it. Treat every comment that you get back like a design review comment. What I mean by that is, if you do design, you'll understand that you submit a design, you get a bunch of comments back. We go through those comments, you go through those comments and you say, yes, I'll make that change. No, this one is not a contract requirement. I'm not going to do that one. Or I can't make this one because of this problem. But you again have this written communication on design submittals. Here's the government's written comments. Here's our comments on those comments. And what happens in the rest of the world, even in construction and supplies, is we get comments, but we don't necessarily treat them like review comments for design. We don't necessarily respond to them, or we don't necessarily get them in writing from the government. And again, I'm going to say paperwork, paperwork, paperwork. If you're getting comments, if they're telling you to change something, you have an agreement. That's how you bid the project. That's how you plan to make a profit on it. And as they're changing it, you need to, again, I'm not making those changes without a comment, and I'm going to then be able to respond to that comment. Yes, I can do that, or no, I can't. Okay? Know the, hitting my mouse there. Know the difference between a variation or, and this is, I bring this up because this is a trip for a lot of contractors. If we say we're giving you a variation, that is a whole different meaning in the government's eyes than it does in the private sector. A variation can mean a substitution, or in the government's eyes, a variation means it's an improvement. So when you say to the government, I'm offering you a variation, or this is a variation to this, they expect it to be an improvement. They expect it to be a betterment, okay? So you want to learn to say the word, I'm substituting an equal product, or I'm substituting an equal design. And that's a difference than an improvement. An improvement says, I'm going to offer you a better HVAC system. I'm going to offer you a better energy system that is going to lower your cost in the future. And the government looks at everything as if you call it a variation, they're going to look at it as an improvement, and they're going to require you to give them a full-fledged study on it and some other documents. It's very timely. So takeaway, we use the word substitution, okay? And again, comments, thoughts, if you have them, please don't hesitate to speak up. I can't even see you anymore because I'm looking at my slides. Modifications, if we looked at the swim lanes, modifications are again, paperwork. It's the written agreement by both parties to change the original contract. These are some rules takes away. Do not start the work before you get your modification. The government rules are very clear. Don't do it. So guess what? Don't do it, okay? You get your receipt of modification. Now, a lot of the government, other government members will look at you with a wink and a nod, and they'll say, the mod's coming, you know, it's going to take us a couple weeks to get the money, and, you know, our process is kind of long, and they like to give you the wink and the nod across the table, like, if you want to go ahead and start, you know, that would be really great. It's not legal. So don't start work before receiving the mod. You'd be surprised that when you kind of hold them to that, politely, of course, when you hold them to that rule, you'd be actually surprised how fast they can move the mountain. If they want something, they'll make it happen. So again, back to Scott Wakefield's steps of things that will help you make up your own contract. Don't start before you get the mod. In the government system, all modifications are required to include a waiver of full accord. A full accord means is that you had one bite at the apple, and when you sign that document, that takes care of all time and money for that issue, and you will not get a second bite at that apple. So if you say, oops, I forgot something, or oops, that is, for example, we had a couple where we negotiated a change order for dirty dirt. We started digging and we found some dirty dirt. We negotiated it up front. We got a unit price. We determined how much we thought. They forward priced it. They agreed to it. They went out, started digging, and said, oh, wait a minute, there's more. Well, it wasn't set up as a unit price or as a not to exceed. You said, I would do all of this removal for this amount of money, and they were denied the extra amount. So you only get one bite of the apple. The government is very serious about their full accord. It's like an insurance waiver when you're in a car accident. You never get to go back and ask for more money, okay? So be very aware to that. That leads us to the next one. Don't sign a mod unless you are 100% agreeable, okay? Because you are giving up all future rights. Do not proceed with the work on unilateral that exhausts the funding. It's not real common unless you're in construction and emergency situations. You should have time and the effort should be put in to get the modifications for any of the changes. But if you get a unilateral, the government reserves the right to say in urgent conditions, here's $25,000, go off and start doing this work because it's very urgent. It may be critical to protecting other facilities or services. Contractors like to go way past the amount. They say, okay, in good faith, I'm going to go out and start working. All of a sudden I got a bill for 50, 60, 70,000 and the government only gave me 25. Again, the paperwork's very clear. Do not exceed the amount of money. Even if it's still on fire, you do not proceed, okay? In construction, there's an NFS clause that says, again, because it's full accord, you have to talk about time. And this may be important on, say, an A&E contract where you have a deadline. Every mod has got to talk about time, and it's supposed to even say no time is warranted. Okay, so this mod is not going to include time. We've discussed it. The parties have agreed. Here's the cost and time, or there's cost and no time. And you want to make sure that your mod, when you're signing it, is very clear that consideration is cost and time. So if you have a due date and you need that extended, you need to make sure that they discuss it and that you have agreed to it. If it's no time, that you've agreed to no time. Modifications are effective the date the contractor officer signs it, no matter what block 3 says. That's just a minor thing when you're looking at your mod. There's usually a at the top of the page, you'll say effective date. At the bottom is where the contracting officer signs it, and the date that they sign it And technically that is the date that the mod is effective. Know the difference between a PC or what the Army Corps is they call it case numbers, but a proposed change is like an RFP. It's like, hey, the government is thinking about changing something. So they are saying, hey, how about if we add the 3rd floor to this building? What do you think? What would you give me a price for? And it is added work. It's really separate work, and it could almost be a separate contract, which is why we're trying to encourage you to think of it as, put your blinders back on. I have this work over here I have to do, but over here we're thinking about this new work. It shouldn't impact you. You shouldn't stop. You shouldn't do anything except price it and continue with negotiations and perhaps add it to your contract, but perhaps not. If the government doesn't get the price they like, they won't award it. An impact or an REA is your right to go and say, I was impacted. This is something that happened. It wasn't discretionary. It happened. I have a different site condition. Somebody changed the design midstream, or they directed us to do it, or we discovered something during the design, and this is an impact, and you can't get away from it. We can't even continue the design or continue construction until it actually gets reimbursed. There's a difference. One of them is discretionary, one of them is not discretionary. Okay, and so just know the difference. The government loves to assign a PC number to it. They love to say, okay, we hear you, but here's your number. But once they call it a proposed change, all of the FAR regulations treat it as a discretionary change. And that is something you can't stop work, you can't earn money, you can't incur money or costs and then bill the government for them. So just be advised, be aware, call somebody, call us, ask us, hey, this is what's going on. Is this really a change or is this an REA? Okay. And the modification will cover it. Again, mod's going to give you the change order for whether it be discretionary or an REA, an impact. But they're going to be done on the same mod. Just know the difference and how you're pricing it, what you're entitled to. Here's one of the things that contractors never do, and it often surprises me, or it surprised me all the time when I was on the other side, but I didn't bring it to anybody's attention because it wasn't in the government's favor, is when you submit a proposal, no matter what it's for, you need to tell the government how long that proposal is good for. When they ask you to bid it in the initial phase of the construction or the contract, they ask you how long is your bid good for, and they have to award it within that period. The same thing with any change order. I hardly ever saw a contractor say this price is based on receiving a mod within 30 days or 60 days. It's only good for that period. And if you don't award the mod within that period, my prices may change. I reserve the right then to reprice it. So make sure that any proposal you ever submit, take one takeaway from this, that would probably be the one I would recommend, is make sure that when you're submitting proposals that it includes a date. This proposal is based on receiving a mod by this date. If not, I reserve the right to include extra cost, okay? Protect yourself. A little minor thing that if you're really attuned to it, on the mods, the FAR, believe it or not, delegates responsibilities to both parties. The government does not have a carte blanche written open checkbook to do anything they want. The contracting officers are also mandated to follow the FAR, and the FAR will tell them in accordance, you can do changes that involve this under this clause. This clause allows you to do these things, like suspension of work, they can do certain things. Under changes, they can do certain things. And the modification form requires them to tell you under what authority they are issuing that change. And sometimes they get it wrong, and sometimes it's important to monitor how they're issuing that authority. It's not very often. I just want you to be aware of it. So when you're looking at a mod, make sure that you understand the full accord. Make sure that you have looked at the date that it's being signed and under what authority they're doing it. It does give you certain rights that I want to make sure you're protected. Okay, any other questions, thoughts about mods? Okay, oh, I'm going the wrong way again. I want to talk about letters. Again, this is swim lane. Now, a letter is going to be a formal notification to the contracting officer. I can almost guarantee you that every letter is going to be initiated by some sort of action. Either you're responding to something that they are doing, or you are notifying them of an impact or something that's going on. It really is formal communication. You wouldn't just write to them and ask them a question or how their weekend was. So again, the letters have a very specific format, and And most issues by contractors that get denied are because of poorly written letters. And I can guarantee you that the government, again, loves their paperwork. They are not going to interpret it for you. They consider themselves, and they are, stewards of the taxpayers' dollars, and it is their burden and responsibility to protect the taxpayer, not you. So if you haven't explained your case, if you've used the wrong clause you're seeking recovery under, if you haven't told them what it is, you haven't substantiated it, they will deny it on behalf of the taxpayers. So letters are very, very important. And I spent a little bit of time putting together a format and making sure that you address these things. So I want to go through them. Make sure that when you send any letter in, you are serializing that letter. And it's 1 through 20 if it's to that client. If you have letters that you send off to maybe a subcontractor or a different part of it, same contract, you don't use the same sequence or serial numbers. So every letter to the contracting officer or to the government, generally they're written to the contracting officer because, again, the contract requires us to notify the contracting officer, have to be serialized sequentially and without missing a beat. And they should do the same. You'll notice that the government does the same to you back. It's very difficult if you end up in court. And again, you're always assuming that this is the worst possible thing that could happen is I've got to take the government to court, or I have to justify this. And if there's any missing serial numbers, or you haven't even serialized your letters, letters may appear, letters may disappear, and you're going to have a hard time proving. Again, serialize your letters. Address them to the contracting officer. Always, always, always. Even if a technical person, an engineer wrote a letter to you or asked you for something, it is always written to the contracting officer. The FAR requires it, and in the cases of, again, if we end up in the worst case scenario, we're in court, we have to explain we notified the contracting officer. No matter who we copied or no matter who was actually reviewing it, it is addressed to the contracting officer. Make sure that you put the project title either in the reference, you can have 2 lines up there, you put the reference with the contract number, and then a subject line, or in the same subject line, here's my contract number, here's what my issue is. The government, at one time when, right before I left work, I was a supervisor, and we had 100 plus active contracts that my staff and I were handling. And if you didn't put the contract number on it, it wasn't up to me to try to interpret what contract it was on. I wasn't even going to look up your name. It was just going to be returned to you. So make sure that you're putting your contract number on it and the purpose for the letter. Like I said, I always challenge people that 99% of the time, your letter is going to be written in response to some kind of contract clause or some kind of contract requirement. So your opening statement should either say, I'm responding to your letter of this date, your request for proposal. I'm notifying you in accordance with this FAR clause, or I am providing this information based on this contract requirement. Open up the sentence by telling them what you're responding to and why you're responding to it. So cite the applicable FAR clause. I have seen letters, and I probably myself did this with, I hate to admit it now. If you cited the wrong FAR clause and you didn't have authority there, but I knew it was something else, again, the government isn't there to help you. They're there to protect the taxpayers, and it would be denied till you figure it out. Sometimes you'll get a great, gracious contracting officer that'll help you with that. Just you can't always count on that. The first paragraph should always be bottom line up front. They call it bluff, but get to the point. Here's why I'm submitting it to you. Here's what I found, and here's what I'm about to tell you. Get it up front, because contracting officers and technical people will start to scan letters, and they'll start looking for information, and they might miss your point. So bottom line up front. Tell them why you're submitting the letter, what happened in a short summary, and what you're about to read or what they can expect. Are you going to request additional money? Are you requesting direction? Tell them up front. Then break out the bullets to explain what your situation is. And I have seen more letters than not number their bullets. Now, why is that important? Because if you've written a letter and it has 10 issues in it, and the government decides they're going to answer 2 of them, you're going to have a hard time figuring out what the other 8 were. They don't like to pick them out. So number them. Give them, this is a point, this is a point, this is a point. And I expect you, government, to respond to each of those points, yes or no. And it helps them stay organized, and it helps you get your responses. At the end, of course, you're going to summarize what you just told them and what they're about to see. And here is the critical part of all letters. This is what trips most people up. Are you asking or are you telling? If you're asking for the government to give you a response, if you're asking them to give you direction, you could be waiting a very long time. So decide, am I asking them for direction, or am I telling them this is what's going to happen? This is what somebody told me, and unless you direct me otherwise, contracting officer, I'm going to proceed. Again, you have to remember, like I said, I had 100, 150 active contracts that 6 of us managed. And at any time, letters may stack up. They notified us, but if they're sitting out there waiting for direction, I may or may not have gotten around to giving them that direction. So you have to decide the tone of your letter. Am I asking for something? If you're asking for something, give them a due date. Very clearly give them a due date. If I'm asking for something, I need it by this date, or something else is going to happen. I got to follow up the letter, or I have to stop work, or I have to stop my design, or I have to do something. So if you are looking for, if it's an ask letter, you need to give them a due date. If it's a tell letter, you need to tell them what you're going to do unless you receive direction to the contrary. And this is very important because so many letters are just left open-ended. And again, they're like PPIs, and we're going to talk about PPIs a little bit in terms of when you're asking questions prior to award. What are you asking? And the government loves yes or no questions because, again, they don't like to share too much information. So in letters, when you just kind of are ambiguous, like, hey, here's my notice, but you haven't asked or told them what you're going to do, it's just here's my notice, they don't necessarily know when to respond by. And again, they're not going to necessarily interpret it, and they definitely are too busy to call you up and ask you what you really need. So make sure that when your closing statement, and by determining if you have an ask or a tell letter, it's going to drive how the rest of your letter is formatted. So, ask or tell. In most cases, I would recommend now you tell them, if this is what so-and-so directed me to do. I went to a design meeting, so-and-so directed me to make these design changes. We put them in writing. I see this as a change. I'm going to go ahead and make that change unless you direct me otherwise. And that will have an impact. It may have a cost down the road. And tell them you're going to do that. Or I need your direction to make those changes, but I need it by next Wednesday because that's when my time frame is up. So again, that paragraph is very, very critical. Who has action and what is going to happen? It always helps if you set up a tracking. If this is if you've cited a FAR clause that says I'm entitled to this, or I have to ask you for this, or I have a differing site condition, or I have a suspension of work, or I've got a change, you're going to track it. Again, back to Scott Wakefield's list, we need to track it. We need to keep separate costs. We need to put the proposal together. We need to track it on the schedule separately. So we can keep all of these costs, all the considerations separate. You also want to close the letter by saying who is authorized to act on your behalf of the company, who can they contact, and who is authorized to act on the behalf of the company. Sometimes it's a technical person, and you should say that. If you have technical requests, call and tax so-and-so. If you have contractual issues or want to negotiate this, contact so-and-so. So who's authorized to act on behalf of the government? And of course, it's always signed by somebody that can speak for the company. Okay. Questions, thoughts? Anybody have any questions on letters? This is really key because more often than not, you think you've written a great letter, you send it in, and it never gets answered. And when we dive back into it, we find out you never really gave them a requirement or response time frame. Okay? And touch on RFIs very quickly. RFIs and PPIs, pre-proposal inquiries. If you do much contracting or bidding, you're going to find that pre-proposal inquiries ask questions ahead of the contract award. RFIs or requests for information are issued after contract award. And they're documents that are relatively informal by nature, but they are asking questions. I need to understand this. After award, it's usually questions that need clarification. There's a conflict in the drawings. There's a conflict at the site. I can't find the product you called out. I have this issue that has come up and I need to have it again documented. The government loves their paperwork. Okay, so they have these forms. They can do them as design clarifications. They can call them RFIs, requests for information. If it's before award, it is a PPI. And again, I have read thousands of these, and Terry and Mary Jo can attest this. And when they're not written well, you're going to get a horrible answer back, and you're going to waste your time redrafting that question. So I just want to talk about a couple things. One, make sure they're serialized, whether it be design clarification, RFI, PPI. Again, you have to have a number, sequential number for them. On the information requested, you're going to reference, it may require you to identify what paragraph, what section, what drawing number, what spec number. Again, the government loves their paperwork. Generic questions just off the cuff without any kind of contractual reference are treated like that. It's just a generic question, has nothing to do with our contract. So again, you need to find a reference. What is going on in the contract document that is we're going to draw attention to? It's either incorrect or a conflict or a change from what's actually in the field, or we went out and investigated it and now this differs from what's actually going on over there. Okay. When you're writing your RFIs and PPIs, you want to get to the answer that you want. We actually encourage you to write yes, get to a yes or a no. And when I give this class, I do give a very detailed class on this. We dive into some of them. Contractors seem to think that if they say, this is how we've interpreted your contract, we see a problem, this is how we interpreted it, do you concur? Okay, you got to a question, and it can be yes or no, but the general option here is, what if they say no? Now you haven't gotten the answer that you want. So you need to get to the answer that you want. If you're telling them this is how we've interpreted the contract, this happens a lot on PPIs. We've read your solicitation, it's confusing, so we think you mean this. Can you confirm, yes or no? What happens if they say no? Now you don't know what it is that they really mean. So that's a really bad PPI, bad RFI, bad design clarification. If you're saying, this is how we interpret it, can you confirm? So get to a yes or no. Do you mean this? Do you want this? Please clarify this. We're trying to get to a yes or no, but do you confirm is not the right way to get to there. And for message, you should always, again, start out, why am I asking this? Follow the same format that you kind of do on a letter. Why am I asking this question? Is there a conflict? Is there a differing site condition? Is there a problem? Did I get direction during a design review meeting? Why am I asking this question, or why am I bringing this point up? And if they don't know that, they're going to, again, just start reading it, and they're going to not kind of wonder where you're at. Again, the middle part, give them the points, give them the information, give them the points, pictures, drawings, sketches that conflict. Give them the information that they need to address. Again, just like a letter, I would bulletize those. These are the points that I see. You need to address each of those points. In the summary, you're going to say to them, this is what's going to happen. Again, are you asking or are you telling? Are you asking for information? If so, you need to tell them again, what's your due date and exactly what information are you looking for? Do I need that? Do I need that voltage that's going into that building, that report that you have to give me before I can even start the design? I need it by this date, otherwise you're going to impact the schedule. Okay, so you have to give them a response date. Or tell them, I ran into a brick wall when I was trying to install this conduit. I'm going to move it 2 inches over, which is really no big deal, but I need to document the file. That's where I put it so that everybody can see it on the as-built. And I'm going to go ahead and do that unless you tell me I can't do that. It's no cost. We're just going to do it unless you tell me no. So again, is this an ask or a tell? So follow the same format that you do on a letter. Make it very pointed, make it very clear, and help them help you. Down here below in the middle, usually on an RFI, if you are using this RFI, they want to know, when you're talking to me, is this causing a cost impact? Are you talking to me? Again, this is communication, and this comes up an awful lot. How you address whether it's a cost or not is going to help them with their decision. If you say, I will make this change, but it's going to cost you, that will help them make a decision, yes or no, do I want to spend my own money doing that? If you say to them, hey, we're proposing this betterment, we're proposing to change this, this is a variation, whether it's improvement or a substitution, is this substitution acceptable? If you put no cost, they're saying, yeah, okay, it's no skin off my nose, I get it, we're agreeing to make the substitution at no cost. So that's why the government is very adamant that when you're discussing this with them or asking them questions, they want to know, is there a cost or not to what you're telling me? Well, most people, and I can tell you by personal experience, that I have pulled out these RFIs when they have marked no cost, and then they've come back later and say, oh, that was a price increase, here's my REA for that. And I have pulled out the RFI that said this was no cost. You were communicating me on paper that this was no cost. That was my understanding, and that was the basis of my agreement to do that, or my team's agreement to do that. So oftentimes when you check that, because you have to, but you don't know. So the closing statement I recommend now is the cost impacts are directly related to your response, okay? I can't tell you if it's a cost increase or not until you tell me what your response is or your answer is. If I can't move that conduit over 6 inches into the next stud, and I have to reroute it to the other side of the room, that's a cost, okay? So you don't fall into the trap of having to say at the time you're asking the question and you don't know the response, whether or not it has a cost or time impact. Be very cautious of that. And the only way to get away from not marking those blocks or saying that somewhere is by saying your answer is going to dictate whether there's cost or not, okay? Again, most of the forms by the government, they like to add this little thing at the bottom that says, by the way, nobody signing this technical response is allowed to make a change to the contract. You will always find any RFI that comes back generally marked right here. This is for clarification only and is not a change to the contract. What that means is, and you say, no, wait a minute, that is a change. That means you need to get out of the swim lane for the RFIs, you need to walk over to the swim lane for the letters, and you need to notify the contracting officer that in accordance with the response provided to this technical clarification, this is now a change. And that's why there are different swim lanes. RFIs, PPIs, any kind of design clarifications are a swim lane, but they're technical in nature, do not change the contract. Once they do, get out of the pool, walk over to the other swim lane and notify the contracting officer. Again, now we follow those rules. I don't make any changes unless the contracting officer tells me to do that, okay? Comments, thoughts? I'm gonna assume somebody's still with me. Changes and impacts. I'm gonna talk on this a little bit. Again, this one is driven towards construction. One of the things that I would recommend is, well, let's go through this first. Contractor seeking an equitable adjustment bears the essential burden of establishing the fundamental facts of liability, causation, and resulting injury. This is in the FAR, it's upheld by the courts. The burden is on the contractor. The burden is not on the government to make your case for you. Again, stewards of the taxpayers' dollars, they're going to try to get everything they can for you at the cheapest, no impact cost point. And the burden is on you to prove, in fact, that you have an impact. Contractor must show that the increased cost arose from work which was materially different from that contemplated by the parties. Again, you're going to have to document, this was not in my bid. This was not how we understood it during the design. This was a change from my original concept. This is going to result in more money, okay? If we made that. In design, and I know Melissa's with us and the other A&E firm, you're going to get technical, what we call technical trade-offs. During the design review meetings, you're going to make concessions. Those need to be documented, and you need to agree to them only if you can do them at no cost. What happens, though, is you've made that trade-off. You didn't document it properly. After you get award, after you get the design accepted, they come back and they say, well, wait a minute, this doesn't meet the RFP requirements. I don't have a vinyl floor. What do you mean now I have a concrete floor? You're going to say that was made, that technical trade-off, that adjustment to the RFP was made during the design review meetings. If it's not documented, if you don't have permission to make that change, if it hasn't been agreed upon, the RFP rules, and you could find yourself doing redesign. We don't want to do that. So again, you have to be able to follow these swim lanes. I've been told to do this. It changes my agreement. It changes what we did, and I'm entitled to an equitable adjustment. Or I agree to do it at no cost if the parties agree. You need to make sure that it supports your case. Again, is it a change that the government's requesting? Is it something that was changed and I'm entitled to consideration? Please, mom was wrong. Please is not the magic word. As Mary Jo, Terry, and I can attest to, is contractors would come in all the time and say, yep, I know I was supposed to have notified you. But now I'm at the end of the contract. I couldn't absorb all those costs. I lost money on the project. Please pay me. We can't do that. The government has rules to, again, protect the taxpayers. One of the contract officer's greatest fears or what I used to call it is, I will not appear on 60 Minutes with my face blurred trying to explain why I felt bad for a contractor who just lost money on a contract, even though he bid it, even though he was competitive, and even though other contractors didn't get that award because we gave it to him. We're not paying him more now. We had an agreement. They didn't follow the rules. So this is why paperwork. One of the things that I would strongly encourage you to do for any contract that you have, and I have not done it for design or for services or supplies, is again, the contract, I would take your clauses, make yourself a clause book that will help you on a standard contract. If you go through your contract, there's always pages, a couple pages of FAR clauses by reference. If you have the time, print them out, put them on one page. I do that now for all my construction contracts because they change project to project. I just got done doing one we got a new award for. It was 110 pages, and that's very helpful though, is that I pass that out. But once I collect all those clauses that are in my contract, I then can start doing word searches on them. And this is something I haven't done for services or A&E. I've done that for construction. Here's the construction FAR clauses that construction contracts are allowed to seek recovery on. These are rights and privileges, rights and reliefs. You know, this is what I have to do, and this is the relief I'm offered if it is a change, or it is a differing site condition, or it is default, it is suspension of work. And each of you will have the changes clause as a minimum. Yours might not be -4, it might be -1, -2. You may not have differing site conditions, but you will have default. You know, if you've been, a default is a global that says you couldn't proceed from acts of God, or in the case of COVID or things like that, strikes, there are provisions that allow you to basically get time extensions. There's always suspension of work, suspensions of work in services and supplies, just different numbers. There is a couple more here for construction on inspection and time extensions and government property. But you should do a word search and find out what your clauses are that you're entitled to get relief under. And you probably do equitable adjustment, or the contracting officer shall, and you pull those clauses, and then within those clauses, we can help you figure out whether or not you're entitled to cost, or whether it's just time, or whether it's time and money, and what your obligations are. Each of these clauses give the contracting officer authority to do something, but it also identifies what the contractor's responsibilities are in order to recover that. You have to respond within a certain amount of time. You have to provide a certain amount of information. And you need to make this chart so that you know, not only when you're writing your letters, which clause to cite that I'm seeking recovery under, but what the contracting officer's rights are and what your rights are. So put together a clause book. We'd be more than happy to help you at the PTAC. Put it together as a standard. Go through it, figure out for services and for A&E what your recovery rights are and what your obligations are. Because most contractors miss this, okay? For example, and these are just some examples that we'll run through. In construction, it's firm fixed price, so it's not just construction, but it's changes under 243-4. If you need a really quick lesson on FAR numbering, you'll see that the 52 means that it's a FAR clause. It's a clause that affects the conditions after award. If it's a provision, it affects your bid. It tells you what has to happen before you propose on it. Clauses tell you what you have to do, or what the rights and recovery are, or responsibilities are after award. The 52 tells you it's a clause. The 2 is just a number that has no bearing. The 43 tells you which part of the FAR clause it is being referenced from. So which part of the FAR sections does this clause pertain to? Meaning you're going to go back to that section. 43 happens to be modifications or changes, modifications to the contract. And then -4 is just a sequential numbering. So this tells you that in accordance with the modification section of FAR, they are required to put this clause in your contract. And it identifies what the contracting officer has authority to do. And it also states what your responsibilities are. Now, I've only copied part of it here, but again, I'm pointing out to you that you have to give the contracting officer written notice. And again, here's the requirements of what you have to provide in that written notice. Contractors just skip past that. They just say, oh, I had a change. I'm expecting you to understand. Well, no, they need to know the date, the circumstances, and the source of the order. You actually have to start naming names. You know, John Smith, the technical representative during design meeting, told me to make this change. The client, Mr. So-and-so, told me to make this change during a design review comment. And you have to state in there emphatically that you believe that this is a change and why you believe it is a change. We didn't bid it that way. Our design didn't include concrete floors, it included vinyl floors. You know, this was a part of our, this is what we bid, and we view that this comment or this direction is a change, okay? And then it goes on to say the contracting officer shall make an equitable adjustment. Again, it's saying both parties' rights and responsibilities. We home in on this because the contracting officer shall being not an option, make an equitable adjustment and modify the contract in writing. Again, this goes back to why we don't do work without it in writing. The contracting officer, we're required to notify, contracting officer is required to make the change, okay? See, in paragraph E, it's going to say the contractor must assert its right to this adjustment within 30 days. There's our cap, okay? If we don't respond within 30 days, it could be dismissed. So we need to know what each of our clauses says and when our obligation is to report it. Here's just some changes for construction. This is some of the things that could be, I mean, changes is pretty global. These are some of the things that would result in a change, misinterpretation by the government. They're all out in the field. The government says, I don't think it means that, it means this. I'm not going to approve this work. That's potentially a change. Defective specifications is considered a change. Usually if the work cannot be performed, you've asked me to design something, but I can't get 10 pounds of this in this 5-pound bag. It just won't work no matter how many ways I design it. We ran into this problem. We were trying to put new equipment in a 60-year-old building that the footprint with the concrete walls wouldn't allow this new equipment because of the new conditions and the new cooling requirements. We couldn't fit it in there without removing the walls. It was a defective spec. If we couldn't remove the walls, we cannot physically get the new equipment. You can't buy 60-year-old equipment anymore. The new equipment would not fit. It was a defective spec. No matter how hard we tried, it wouldn't fit. Government interference or failure to cooperate. Again, this comes in a change. A change could be that the government did not give you your review comments back in a timely manner. We have a contractual obligation. Both parties' timeframes are outlined. You had 20 days. You didn't do that. That is a change to the contract. So again, anything that changes the written terms could be considered a change. If the government doesn't respond to the review comments, design reviews, or the submittal review comment or submittal reviews in a timely manner, that's a change to the contract, and you would cite the change clause as that reference for that impact. Superior knowledge and failure to disclose. The government knows something or should have disclosed something to the contractor but didn't. This happens when you run into like dirty dirt or things, asbestos. You know, the government has a responsibility to tell you that they tested that paint or that they know that that's a hazardous waste site or whatever. Again, that kind of falls into a different site condition, but it could also be a change. They knew something they didn't tell me about and they failed to disclose it. Does it make it a defective spec? Can I not do it, or is it a change condition? All of those things might apply. Government tells contractor hurry up. Those are things, again, changing. You're asking me to reduce my time frame. So there's a lot of things that fall into the changes clause, and every single contract has a changes clause. So again, here's just a little quick cheat sheet. Again, in the blue is what is required, the date, time of the occurrence, the action directed, the individual directing the change, the action is perceived as a change, and then what action was taken by the contractor. And this again is where we get into the ask or the tell on that letter of notification. Am I moving forward? Am I not moving forward? What did I do? Did I have to suspend work? So what action is being taken by the contractor? On the right side is just some things that could fall into that. A review comment could be a change. Response to an RFI could be a change. A non-compliance notice. Generally, they aren't issued except for construction, but that would be the government out there saying, nope, that doesn't comply. Here's your notice that you need to change that out. Well, that may be something we don't agree on. We think we interpret the contract one way, you interpret it a different way. Government fails to reform as agreed in the contract. Again, usually design or review, submittal review periods. Email directions. Both parties right now are terribly guilty of using emails to do business, and you may get an email that says resubmit the schedule, resubmit this. That's direction to change something, and that could result in change. Any other verbal or written direction received in a meeting, on site, by telephone, even if it's in the presence of the contracting officer, it could be a change. So make yourself a little cheat sheet. Same thing with differing site conditions, and I don't think we have any construction firms on, so I'm just going to show you just again, when you pull them, each of the clauses has what your conditions are and how you have to respond, what the contracting officer has to do. In the case of the differing site conditions, it says the contractor shall promptly and before the conditions are disturbed. So this isn't even a 30-day notice. This is you're digging, you run across something, you hit a power line, you hit a conduit, you hit something, dirty dirt, and you have to notify them. You have to back off and you have to notify them, and you have to get direction before you can proceed. So this is immediately and before the site is disturbed. So this is telling you you don't have a window, you don't have a 20-day notice, okay? And then it tells you what it means. It then tells the contracting officer they have to investigate promptly, and they have to make this determination, and they have to make an equitable adjustment and do it in writing. So again, both parties' rights and responsibilities are called out. It's not just ours, it's not just theirs, it's the conditions under which we agree to comply with. So you need to, again, pull your clauses for your specific contract, find out which ones you have rights and responsibilities under, and then find out what the contracting officer's rights and responsibilities are. And this is where I tell contractors, again, back to Scott's original thing, is you don't act until you've got your mod, you've got it in writing. And this clause says you don't act until they give it to you in writing. Okay? Request for a contractor for an equitable adjustment under this clause shall be allowed unless no request by the contractor for an equitable adjustment of the contract in this clause will be allowed unless the contractor has given the written notice required. They're very clear again. You were told to give written notice. You were told to do it before you disturb the site. You don't get to come back later and say, oh yeah, I ran into this, but I took care of it, okay? Differing site conditions, again, here's just a cheat sheet. Here's what you have to do. Here's what may happen. Default, this should apply to almost all of them. This talks about that it's interesting that the rights and responsibilities are listed in the contract that starts out by saying, you know, if you don't meet your schedule, we can default you. But if the delay is beyond your control and for unforeseeable causes beyond control without fault, including these examples, we basically won't default you. At the end of this, it'll say, if these conditions apply, you will get basically time. So here's some of the things that you would be looking for. And again, you want to know what your default is. You know, acts of, and I've highlighted the one there, the rest of them seem pretty easy. I had fire, flood, you know, epidemic, which we're currently in, strikes, you know, severe weather is always covered here. Acts of the government in either its sovereign or contractual capacity. If I was delayed from proceeding because of the contractor, either in their sovereign or their contractual capacity, if the gates are closed, if they fail to respond to review comments. Now, back on the cheat sheet, you're going to find out that under default clause, you'll get time and no money. So this is not where we want to focus our attention on submittal response times not being met, okay? But if in a contractual capacity, the government didn't do what they said they were supposed to do, they didn't give us our badges on time, they didn't, they acted in their sovereign capacity, delayed, closed the base, things like that, that would be covered under default. And again, you have to give them notice. Within 10 days of beginning the delay, you have to notify the contracting officer in writing of the cause of the delay, okay? Contracting officer will ascertain the facts. Again, here's your responsibilities, there's their responsibilities. And if they find that it does warrant it, time for completing the work will be extended. This clause allows the contracting officer to extend the contract, but no money. You only extend it for time. Now down here at the very end, this doesn't seem necessarily fair. Down here at the very end, it says the rights and remedies of the government in this clause are in addition to any other rights and remedies provided by law or under this contract. And I draw that attention to you that if you, let's say, for example, we have had a lot of COVID-19 delays. When you write the letter to the government, you say, in accordance with the default clause, I'm delayed because of COVID. It's an epidemic. This is an excusable delay, but you're not going to get any money for it. But now you have an increase in price or you had to do something else. You need to cite another clause in order to recover those costs. Now the government's going to try very, very hard to deny that. They're going to say, nope, it's default only, here's your time and no money, but you at least have to give it a shot. So again, knowing your clauses and knowing which ones you can recover what under is very important on how you write the letter. If you only send in the letter says COVID-19, is a epidemic, is covered under default. This is an excusable delay. You will only get time. Okay, so just be aware of that. Again, default. Here's what you have to give them in the letter. Here's what could cause that. So just some examples. Inspection and construction, I won't go through this except to mention that these clauses, when you do this, talks about, and that's why I would research for equitable adjustment. Once you print out all your clauses, go through and search for equitable adjustment, and you're going to find all the clauses that you have some recovery under. And then specifically print those out and figure out what it is your rights and what are your responsibilities. How do I notify them? In construction, the government reserves the right to have you rip something out and test it if they don't think it's going to work. This clause says if it was not wrong, they pay. If it was wrong, you pay, contractor. So again, here's the cheat sheet. Use and possession is generally a construction. It could be in service, could be in supplies. If you haven't gotten paid, the government takes possession of it, they start using it, they destroy it, you're due an equitable adjustment if something happens. Again, here's what your responsibilities are. Suspension of work will always apply to all of them. They have different clauses again. Off the top of my head, I can't recall what the other titles are. I only know suspension of work, but there are some for services and supplies, and those. But again, here's the requirements. You know, if the performance of all the work by either an act of the contracting officer or the failure to act. I draw attention to this is that the government likes to say, well, I didn't give you a suspension notice. I didn't tell you to stop. Well, your act or failure to act, you should have given me a suspension. The base was closed. You know, you had the obligation to notify me that I was suspended, and they didn't. So this clause covers both. It says the contract officer is supposed to do something, or the contractor's failure to do something could constitute a delay. Okay, and an adjustment shall be made for any increase in the cost of performance. Now, interestingly enough, suspension of work covers cost, doesn't cover time. So again, we're going to have to reference two clauses. Maybe it's a suspension of work in default because I was suspended from moving forward. I want my time and I want money. But again, you have to know this one covers cost, default covers times. You can't recover both. Okay. Again, down here, 20 days before the contractor, for costs incurred more than 20 days before I provided notice in writing. I would recommend you never wait till the very end. I would recommend that you get it in immediately as soon as it happens. But again, rights and responsibilities and who has to do what. And each of you will have a suspension of work clause. It's just you have to figure out which one's in your contract. Again, what is covered, what's required, and then what could be a cause for that. Okay. Time extension applies only to construction. I won't even go into that. But REA steps, when you're looking at those clauses that I just referenced are all generally requests for equitable adjustment. There's always something that has happened that is not in agreement. It happened and that's preventing the performance of whatever we agreed to from either being delayed or from being changed. And here's some of the steps you need to put in your notification, okay? You need to tell them, I'm notifying you, either you're gonna do it in an RFI initially, but again, remember they're not allowed to make a change, or in a letter. So initially the RFI could say, hey, I ran across this differing site condition, what do you want me to do? I ran across this design deficiency, what do you recommend we do? And based on that answer, then it could have cost impact and I need to move it to a letter. Again, remembering which swim lane you're in. Second rule, document and track. We'll clear back to the lead-in slide that talked about what Scott was talking about. Is if you don't document, you don't track it, you don't keep it a separate cost, you're never going to be able to recover what you're actually entitled to. Determination of merit. This is one of the key things. As you put them on notification, the government may agree or they may not agree. They may say that's not a change, it's in your contract. They are required to tell you that. They are required to have that communication and tell you whether they agree it's a change and you're moving down the road of being able to collect the cost, or no, it's not a change and they need to tell you get busy and get going, and no, it's not a change. So once you notified them and you're starting to document, you need to get them to acknowledge that it is a change. And sometimes this is like pulling teeth. You got to get them to say, yes, that is a change. Excuse me. But that is one of the first things that you have to do. If you cannot get a determination of merit and you just happily go along and you've made the change, same the design, we've submitted it, we've gotten all the way to the end, and then somebody comes back and you say, well, by the way, you owe me some money for that. And they say, well, no, we never agreed that that was merit. And you're going to be arguing it forever. So again, these are your steps. Notify, start tracking, get a determination of merit. Somehow you've got to get them to agree that it is a change. And then of course you have to submit an equitable adjustment. If necessary, you're looking for time and or cost, and you're trying to decide, do I want the, do I need the equitable adjustment up front, or can I not even price it? If you cannot price it up front and you're waiting for recovery at the end, it is much harder to get. Once the government's got what they've wanted, the design is submitted, the construction's done, they move very slowly when it comes to getting the your recovery compensated back to you. We find it very successful to say, I'm not moving forward. Matter of fact, we just received a suspension of notice for 8 months. So we've been cut off a job because of access in the government. We can't go back to the job for 8 months. And we submitted all proper notification. They've actually suspended us, so we didn't even have to get a determination of merit. But we sent them a letter and says, we will not return to work until you give us a mod for the impacts. So you're being advised that in 6 months, we're going to give you a proposal, but we will not return to work because you are required to give us a proposal. You are required to pay us for that impact before we ever get to it. If we had just gone back to work in 8 months and waited to recover it at the end, it would be probably years before we actually got the money. So know when you're entitled to it and when it's required to get it. Okay. And again, some trips. These are trips that might affect you, but underestimating the government's reliance on the FAR requirements. Do not assume that they fully comprehend or are going to tell you what your rights are or what their obligations are. That is something that is inherently an obstacle that they do not like to share. Failure to recognize the government process. Again, back to Scott's lead-in. If you don't document it, if you try to help them, if you don't follow their process. We just went through these FAR clauses that were very specific, and the government believes in their processes. They are very much addicted to them. They are live and breathe these processes. And if you don't recognize those processes, if you think I can just call the contracting officer up and tell them, hey, this is an impact, I know we're going to be able to work this out, they're going to have short-term memory loss. Okay. So recognize their process and live by their process. Failure to provide timely notification. Notification is essential. Again, we just walked through those clauses. It's very specific. The courts, there are a lot of court cases that said, okay, he missed the window, but it definitely was a benefit that the government received. It definitely was a change, and you cannot basically deny it based on this administrative thing. But that's going to court and having to fight it out. You want to make sure that you provide timely notification so they don't have a reason to deny it at the entry level, at the first lowest level possible. Okay. Failure to cite proper relief clauses and assert their rights. Again, that's all process. We walked through that. If you don't say who told you to do that, if you don't say what happened, if you don't identify the documents, if you fail to cite the proper relief clause, again, this is like saying my default, I have an epidemic, I can't get this work done, or my vendors had to shut down, or I can't get access to steel now because of all of this. And I do have a cost increase, but I only cited the default. They're going to back and say default, time only, sorry, you're not going to get any money. So again, know your proper relief clauses and assert your rights. And if under the default one, you say, okay, I see it's an epidemic, but it's also a change because this is what happened. At least you've got to cite those in order to even try to assert them. Failure to provide supporting evidence. One of the things that I always say, if you make me read the contract, I used to tell my contractors, if you make me read the contract, I will. Now, if you give me all the documentation, if you show me the sample of the drawing, if you cut out the section that you're trying to get me to look at, I will focus on that. If you make me go look it up, I'm sure I can find something else that is not in your favor. So incomplete proposals or incomplete documentation will just sit, first of all, because they've got to go do some extra work. So the better your letter, the better the documentation, the better your odds are. You're helping them help you. Failure to seek direction or state actions to be taken. This falls into poor letters, poor RFIs. Even when you've done the notification, but if you haven't told them what I need or who's doing what or who has action, is the contracting officer required to act? And are we saying we will not act until you do what you're supposed to do? We need to tell them what to do. Otherwise, letters that don't have any action, Don't have any due dates, don't even say who's doing something, we'll just sit. Faith in the honor system, again, back to Scott's 1995. If you believe the government is looking out for your best interest, that is not something you should, you can't bank on that, ever, okay? Waiting for actual impacts. If you wait for the bottom line loss, if you say, oh, well, that was an impact in the design now, but I don't really think it's going to change anything. And at the end of the project, you realize, well, dang, that really did change quite a bit. They don't like the bottom line losses. You have to identify them up front. You have to reserve your right. You can always say, I notified you that that was a change, but at the end of the day, it wasn't, I don't need any money. It was a change, but I don't need any money. You don't have to submit a proposal, okay? So get your reservation of rights in first, but you don't necessarily have to seek recovery from it. But don't wait until the end and say, oh, shoot, I lost a lot of money. And way back under the first design submittal, you guys made this change. Nope, you've lost your window of opportunity. Presenting an emotional case rather than a factual case. This happens a lot, or used to happen to me a lot, where contractors, I had one contractor tell me that his children are going to be eating rice and beans because he lost so much money on a contract. And my point was, well, you know, sucks to be you, because you should have done better. You know, you had these, we have a contractual obligation. The rules and regulations are very clear. You need to follow them. Okay. I'm assuming you're all still out there. Overheads, just, did anybody have any questions about REAs? Anybody?
They're so enamored and paying with rapt attention, they just can't get the questions out.
Is that a nice way of saying they might be sleeping or not? I bored them to tears.
No.
Okay. Well, if anybody has any questions, just holler. The next area that I kind of want to touch on very quickly is just overheads. And we have a whole class. I think I can get this to move forward. Sorry. Just overheads really quickly. We have a whole class on this, so I don't want to spend a whole lot of time. Just know the difference between indirect and direct costs. Indirects, of course, are those expenses that you incur whether or not you have a contract. Direct costs are only those costs that you incur on a specific contract or a specific project. And your cost accounting system has to be set up to separate the two. And there's a very strict, FAR has a FAR Part 31, and the DFARS Part 31 is very specific on what are allowable and unallowable and which one goes into which pot. And when you start negotiating changes after your contract award, which may or may not have any cost detail in it, you're going to need to know the difference, in your cost accounting system going to have to be set up to monitor that. So again, your indirect costs are those that cost of doing business. Direct costs are those that are attributable to an object, a project, that are, if I did not have this project, they would not occur, okay? So again, this is just a very quick, easy, oh my gosh, here's circles. Here's what it costs for me to manage the office and to keep bidding on projects. It has nothing to do with these actual projects out here. The people that I've assigned out here, the costs I assigned out here, if I didn't have this project, these costs would go away. They would not be absorbed here. At the end of the day, you're going to have to track this. This is what you report on your taxes, is what we call G&A, or your overhead expenses, your office expenses. Different from these down here, which is your revenue and your revenue streams, either that or your cost of goods, depending on how you have it set up. And you're going to, of course, come up with a percentage of how many dollars in here then are divided by how much revenue I have out here. The government is going to ask for this information. The government is going to want to see those on change orders. And the government is going to, may ask for an audit, which could be DCAA, Defense Contracting Audit Agency, coming out and looking at your books. Again, we have a whole class on this that if you are interested in that, we want to run you through, because there are some very specific rules, which are coming up here. But again, this is a simple income statement, talks about your revenue up here, your materials and supplies, your gross margin, and then here's all of your admin expenses. Some people call it G&A, some people call it home office. This is all the expenses it costs to run your business. Here's your total expense pool. And of course, you're dividing, you know, how much my revenue is by how much my expenses are to come up with how I'm going to mark up every dollar. Okay. So it's a very relatively straightforward process. But the key that we would talk about, and I'll share with you here, but we can talk about in great detail if we do the overhead class, is depending on whether or not you're dividing this pool by my materials and supplies, or whether I'm doing it by my overall revenue. How you divide it is how you apply it, because you can see there'd be two different, totally different percentage markups here. And the government's going to want to know, how are you going to apply your home office? Normally, they ask for a minimum of 3 years. So if we're negotiating a change, they need to see your direct costs. They can see that. Usually it's material, equipment, and labor. They're asked for receipts, give me some invoices. But on your home office, they're going to say, show me your last 3 years income tax statements so that I can see what your trends are, where you're at, what you're charging me. Now, the key about the government, though, is the government in FAR Part 31 says, because we're the government and because we represent taxpayers, there are certain expenses that you may have in your pool we do not allow, okay? You may have alcohol at your Christmas party. Taxpayers don't pay for that. It's unallowable. You could have bad debt because of other projects. Again, the taxpayers are not going to pay for your bad debt. So in addition to this income statement, they're going to ask you to give them a list and break out all your expenses by FAR clauses to say whether they're allowable or unallowable. And although this is what it takes for you to run your company, the FAR requirements say certain elements of this are not going to be allowed. So your number is going to be different. And there's a separate worksheet that they will make you fill out. And we have a special class on that because FAR Part 31 is very specific. What's allowable, what's unallowable, what the taxpayers will pay for and what they won't pay for. And you have to subtract those out of your pool. And I can guarantee you, as a contracting officer, if when I sent you that worksheet, if you didn't have some unallowable expenses that you separated, I would question what you got going on there, because somebody always has some unallowable expenses, okay? Even to the point that if you have automobiles, but you let the people take those home as a personal benefit, those are not allowable. Taxpayers don't pay for your employees to have their own company vehicle. So we may dive into that and say that's not going to be allowable. Certain memberships to communicate to clubs or whatever are not allowable. Certain alcohol requirements are not allowable. So we would have to walk you through FAR Part 31, or if you don't take our class, FAR Part 31 is what you want to go through. You want to take all of these expenses, which pretty much they all are called out, and they will tell you whether they're allowable or unallowable, or a portion thereof is allowable or unallowable. So if a portion is, again, that might be driving you to set up your cost accounting system to track those separately. You might have entertainment that has alcohol, that does not have alcohol, and I track those separately so that I can at least deduct the expenses that are allowable. Certain recreation cost expenses are allowed, some are not. So again, FAR Part 31, there's a worksheet that we can give you, or if you attend the class or ask for the class, and if you are interested in that, just send Kathy a note. We'll get one set up here in the next couple months, okay? It will always be a percentage. The home office and GA does not change by project. Technically, it cannot be negotiated. The reason I tell you this is you may come up here and say, okay, I'm at 13%. I know this is net income after tax. Let's just say that I've divided this out. I'm at 13% home office expenses, and the government says, I'm not paying 13%. That's just way too high. I'm going to give you 10. Well, this is based on a set formula. It's based on my cost accounting system, and they technically cannot negotiate it. They can take elements out, but technically they can't say it's just too high, I'm not paying for it. And that's the one thing I really want to just draw your attention to in this short, overview. FAR Part 31, you want to go through unallowable, allowable, you want to come up with these records, and just be aware that if these records indicate you have 13, 15, 10, whatever your home office is, it is not negotiable unless they can find some unallowable cost or something that you've not done right. Just be aware of that, because they love to just say that's too high, I'm not paying it. And contractors say, okay, I'll take that 10%. The problem is that you start reducing your home office and you start losing money. I mean, you're not even keeping the lights on in the company if you do that very much. Okay. In some cases, FOO, or what we call FOO, field office overhead, if you're in construction, you will have some of those indirect costs that again apply. I don't think anybody here is construction, so I won't go into that at all. Okay. Rules of the road for overhead, I would like to just remind you of, or take away on that will help you manage your construction or your government contract better, is that you must have an established system. That is the one thing that the FAR does insist upon. You don't make, usually your small businesses don't make enough, you don't have a large enough contract or company that require CAS, cost accounting systems, which is approved by the government. So you don't fall into that requirement, but the FAR says you have to have an established system. You can't change it willy-nilly. You can't charge, for example, lawyers will charge you printing costs by your case, but they can't include the printing cost in their overheads then. They can only charge once. And they can't change it client to client or project to project. And that's what they're saying. You have to have an established system that will withstand an audit, which means you have to have, has to be set up, has to be charged all the same consistently. The rules have changed now that any cost proposal over $2 million must be certified, and the certification is basically the government's truth in negotiations. It ties back to that, and you have to certify that based on your knowledge the information is factual, and if they prove it's not factual, that has a lot more ramifications, but you do have to certify it. When you get to that point, it used to be $750,000. It got raised to $2 million for new contracts. If you ever get to that point where you're confused about that, again, give the PTAC a call and we'll explain it and walk you through it, because you are certifying that it is factual and to the best of your knowledge, true. Home office are indirect cost, and they will always be distributed as a percentage. We walk through that. Unallowable costs cannot be included, and so therefore your home office is going to be skewed, and you do have to have a table that breaks out what is unallowable. FOO, which is field office overhead, is a direct, but it's an indirect. Okay, and unless you have a construction contract, or if you have a construction contract, give us a call, we'll walk you through that. If it's not a definable feature of work, it is most likely, that should be, well, in construction, if it's a direct cost on a project, and it's not an undefinable feature of work, meaning it's not the windows, it's not the walls, and it wouldn't apply to design, so let's just skip past that. Every party is entitled to markups. Just remember that documentation is critical. Again, paperwork. Let's ignore the FOO. Make sure the team understands your pool assignments. A lot of times you'll see individual projects with individual project managers negotiating different rates. That hurts the company, so make sure that your numbers are shared with everybody and how they got to that. And most importantly, how you divide it is how you apply it. Again, we have a class on that, but how you set up your home office, how you allocate your cost, and how you've set it up in accordance with FAR is going to help you recover your costs. Again, here's some trips. Trips would be overestimating the government's knowledge of overheads. They don't know, they don't have them, they just monitor them. Actually, the government is a nonprofit organization for the most part and functions like that. They don't understand home office. They don't understand FAR requirements. They're not accountants. And if you rely on them to understand your process, you're probably going to be come up short. Failure to recognize, again, the process. Again, I'm stating that they're going to give you a form. They're going to tell you to take out the unallowable costs. If you do not understand that you need to do that, you're going to find yourself, again, delayed in the process of getting things done. Failure to understand how your direct costs are allocated. Again, knowing which ones you can charge and which ones you can't. Knowing if you have a estimator that actually leaves your home office and goes out in the field, that your cost accounting system tracks his work separately. So know how your direct costs are allocated, how your cost accounting system is set up. We'll ignore the field office, we'll ignore Division 1. Supporting evidence. If you don't have your tax records ready, if you don't have that allocation sheet taking out your failure to provide this evidence will do nothing but raise the question. And again, if they're looking at just a number and they're trying to negotiate with you and they don't have any evidence to support that number, you go back to the back burner. And again, that doesn't help you get your mod in a timely manner. Assuming common sense will apply is the biggest trip that you will make on overheads. Again, common sense does not always apply when it comes to the government. Waiting for the actual impact. Again, this is relating to the bottom line loss. Not addressing overhead expenses and joint venture agreements. This, again, if you have a joint venture agreement and you set up not necessarily, I'm sorry, I'm stumbling over my own words. In most joint ventures, you do not set up a whole separate company for that. So one of your joint ventures is going to carry the responsibilities of your home office. And it's important to know that in your joint venture agreements and in the negotiations that you're discussing that. So if you ever get into that situation where you have a joint venture agreement, you're talking about pricing, again, give us a call or ask us to do the class and we'll walk you through that. And of course, not taking time to do it right the first time. Government has hundreds of REAs, proposals, things going on at any one given time. They're currently in year end, everything falls. If you don't do it right the first time, you're going to fall to the bottom of the stack. And the whole goal of this, of me giving you this information, is how to stay on the top of the stack, how to get your mods timely, how to get your contract administered with the least amount of impact so that you can get paid, the product can get done, and everybody is happy. There's some information, which I'm not going to go into, but here's a sample of how the proposal packages go together. Again, we have a whole class on that, and I'm running kind of short on time. I want to give you opportunity for questions. So I'm just going to leave you with how a proposal package should go together. Again, the cover letter, your cost and pricing cert, the proposal, how you break it down, and then, of course, any schedule impacts. Okay, so I'll leave you with that cheat sheet, but we can walk through all of your costs and how you make sure you recover costs, like future cost or burned costs or things that you've already incurred. Time, again, time is money. If you have a contract completion date and things are impacted, you need to make sure that you can justify the time. The government, again, believes in their paperwork and has the burden of proof of determining that there was in fact a delay, and how that delay caused is whether it's inexcusable or compensable, how it delayed the schedule overall, whether it was critical path work. And so you always have, if you're doing any kind of services or even some supplies, how your schedule's set up for delivery, how you're going to meet your contract completion date. If you ever need a time extension, you're going to have to prove to them how you determined that time was necessary. In construction, it's a very detailed schedule. I believe that it's a semi-important or detailed schedule for design. In services or supplies, they may not even ask for a schedule, but again, if you have to prove that you have a time delay, how did you prove that? How do you document that? So you have to have some kind of document that shows what your schedule is based on. And again, you're going to have to prove what activities were going on, what happened, where did the impact occur, what, how does this time frame affect it? And it could be as simple as a bar chart. It could be more detailed. Construction has a P6 schedule. But again, if you're asking for time on any proposal, you're going to have to give them some kind of schedule, whether it be a bar chart or Gantt chart or whatever it is that shows what my activities were and when I get impacted and what it did to the rest of the activities. I may not have gotten my submittal approved, but it pushed out production. I may not have gotten the design submittal on time or had the meeting, and it pushed out the whole process because there are remaining activities out there that get pushed to the right. Okay. So again, how the government views it, they might just say, well, that was a 10-day delay. And you go, well, no, because of the 10-day delay here, I actually had to push everything out because of either timeframes or windows or review periods or Christmas vacation or whatever. It actually resulted in a 78-day delay. And you need to have some kind of documentation. Again, construction is very specific. They have an actual schedule requirement. Design will have more of a, here's the contractual requirements and due dates you have to meet. And again, you putting together a chart that says how that's pushed out is going to be critical. Okay. We actually had one little change that we couldn't find a product. It ended up in a 150-day delay. And that is, as you know, a third of a year, and it was just for a door. So this is a very detailed it's very important that you be able to document to the government that this 10-day delay that you thought was simple here, by the time you negotiate all the changes, get all the clauses in, I resubmit it, I find the product, it actually resulted in a 150-day delay. Okay, so critical. Again, here's some information on the schedules, failure to recognize it, whether it's impossible to start with. They rely, if you underestimate the government's reliance on a schedule, if they've issued you a contract and they said this due date is when it is, they will hold you to that due date. They do not care about the rest of it. Overestimating the government's knowledge of the program. Again, they are not accountants. They are not schedulers. They will not have the detailed knowledge. They will need you to explain it to them. And they need you to explain it to them in a manner that makes it simple for even the very simple, straightforward. It truly delineates what is going on. Not reading the contract every time. What happens, especially in construction, is you start to assume certain things are always consistent, and that is not true. Even in design, you know, how many submittals. You'd be surprised how many design packages I saw go out the door that even with the government review period times in there, it actually exceeded the contract time. The contractor didn't actually have any time. All of the 90 days for the design was all in government submittal reviews, and that was a conflict. Failure to initiate start-stop activities, building your schedule impacts when they happen. Make sure that you reference, I put the notification in there for that impact, but again, building these activities, whether it be just a simple bar chart or a detailed scheduling system, you need to show, don't just extend an activity as longer duration. Build a new activity, says this is what the delay was. If my government review period was 20 days and it actually took 30, I have my 20 days originally, and here's the 10 days as a separate activity. I just didn't make it a longer activity. Again, faith in the honor system. Schedule is updated after the fact. That's a big trip for us. Even the courts don't like that. Self-pacing or voluntary suspension of work. This is what happens when the government review period is on a design submittal is overdue and you just stopped work. You just stopped because, well, you didn't have something. That's a voluntary suspension. The government will come back to haunt you on that. Failure to track incidental changes. It may not seem like a big change now, maybe 1 or 2 days here, 2 days there, and overall it does impact you. But again, if you don't get the notices in, you don't build it on your schedule, you're not going to be able to recover it. Okay. Letting the government use the report. This is for construction. Keeping it in real time. Updates are months behind. Make sure that if you have a requirement to give them monthly updates on schedules, sometimes on designs, it's quarterly, that you do that. You don't fall behind or not submit, because again, that's their notification. So I'm not going to talk about getting paid. I guess I'll leave it to questions since we've got just a few minutes. Somebody talk to me. Somebody ask a question.
We're not sleeping. We're here. We heard it all.
So I know that was really quick. It's just, if I could leave you with anything, it's know your swim lanes, because the swim lanes are really the documentation that the government needs, and they're there for a contractual reason. Technical notice, clarification, follow those. Do away with email. Please do away with emails. And then know what your rights and remedies are. And the only way you can do that is to have a construction, your clause book, pull those clauses, know what they say. Keeping them in your contract with just a full list without ever reading them will not help you when it comes to writing a letter and recovering your rights. And the key is, if you follow some of these steps, you're going to keep your project moving forward instead of stumbling or holding up mods or holding up performance. And then you'll be recovering it afterwards. Keep Scott's little 10 things to screw up mess up your contract. Keep that printed somewhere so that you don't fall into those traps. In 1995, they were true. They're even truer today. Anybody have any questions? Burning desire, something specific to you? A class you'd like us to follow up on?
Can we arrange to have both of those classes you were talking about, the overhead class and the proposal package class? Those are helpful.
Sure. Kathy will do her best to rein me into a time frame. And because those are already classes, again, sometimes I run through stuff that's not really relevant, but I don't have to redevelop them. They're already developed, and we'll just find an open time frame when we can do that.
That would be awesome. Thank you.
And Kathy will make sure that if you are registered, she has your email, she'll send you a copy of this package for your records.
And there is an upcoming class later this next month, because it's still September. It's Wednesday, October 14th on government contract ethics. Ethics in contracting.
Mm-hmm.
Is that
And I know it is. And then, of course, next week is contracting coffee hour.
Yay, coffee hour.
Yeah.
It'll be nice to be able to get back together eventually.
Someday.
Yep.
With donuts.
With donuts, I know. Poor donut place is their business must be hurting, so.
Yeah. Okay, if there's no other questions, then I say we all get to get 5 minutes back.
Yay! Put it to good use.
Thank you, Mona.
You're
Thank you.
welcome. Hopefully
Thank you.
hopefully you got something out of it today. Thank you very much.
All right, thanks.
Bye.
Bye-bye.
Bye.